Hello, my name is Ismail Shahtakhtinski, and I'm the principal immigration lawyer at IS Law Firm. As you may know, we have a large practice handling marriage-based cases. Those are the applications for permanent residency based on marriage with a U.S. citizen or permanent resident of the United States. One of the questions that frequently come up is whether a conditional permanent resident who obtained his or her green card based on marriage will lose their green card if the marriage doesn't work out, if they're separated or divorced, and so on. So as you may know, the initial green card obtained through marriage is valid for 2 years, as long as the couple has been married for less than 2 years at the time of the approval of the green card, which is usually the case. And after 2 years, they have to file another petition jointly, confirming that they've been together so that the beneficiary can obtain the 10-year green card. So what if the marriage falls through? What if the couple is separated and divorced during that time? The answer is not as simple. There is a formula. It's a bit complicated. It depends on the nature of the relationship, whether they're separated legally, knowing that there is no possibility of reconciliation, or whether they're going through difficulties in the marriage, which is normal, it's acceptable, and even if they're separated, as long as they file together, they sign the petition together, and they're not divorced until the approval of the petition, then that should be fine as well. Now, if they file for divorce, then there is a way to file for the renewal of the green card, even without the divorce certificate, but mentioning that you are in the divorce process and so on. So if the marriage falls through within the first 2 years, you should definitely consult a lawyer and hire a lawyer. If it's past the 2 years, if you already have your 10-year green card and the marriage didn't work out, there is no risk, no harm. But at the time of the citizenship, because, well, there is no harm because you don't have to file for renewal. You already have your 10-year green card and it's not conditional upon your marriage. But at the time of citizenship, a question may come up about the validity of marriage. So it could be a factor to the government. Even though you have a 10-year green card, the government can look into your prior marriage once more before granting you citizenship. In any case, if your marriage doesn't work out and you are a permanent resident, whether if you have conditional green card or 10-year green card, it is advisable to at least consult with a lawyer, find out if there are any nuances in your case, anything that you should be cautious of and careful of so that you don't get into trouble. Good luck to you, and thanks for listening.